Hello, and welcome to the first episode of Family Law Lattes. This podcast is for family law professionals in England and Wales who are looking for straightforward, helpful tips or toolkits to tackle all aspects of family law. Basically, something you can listen to for half an hour whilst you're enjoying your cup of coffee. My name is Melanie Bataillard-Samuel, and today I'm joined by Roxane Reiser. Roxane is a family law barrister at Hare Court in London. She specialises in cross-border divorce and financial remedy proceedings, and frequently deals with cases involving issues of jurisdiction, recognition, and enforcement. Roxane has also been admitted to the Geneva Bar in Switzerland, where she is an associate in a leading matrimonial law firm. Our first topic is a thorny issue of family law after Brexit. Hello, Roxane.
Hi, Melanie.
Thank you so much for being the first person to come and talk on this podcast. So no pressure, but it's all on you to make it a success.
Thank you.
So we're going to be talking about Brexit today.
Very good.
And it's really just going to be a chat about, well, everything I'd like to know about family law post-Brexit, because as we've discussed, I have loads of questions.
Very good. Excellent. Well,
first of all, tell me how you're doing. Have you got your coffee with you?
Yes, I do. I'm on soy latte at the moment. I'm afraid I'm one of those people. But yes, so all good with me. I think it's been a challenging start to the year for many family lawyers. So it is a nice opportunity to be discussing those issues in a more relaxed setting, if I can put it that way.
Definitely. Well, I've got my black espresso, which is what I've been working on all day. So, right. So basically, tell me, what's up with family law post-Brexit? Because we had loads of talks, like up until Brexit was happening in December, everybody was guessing what was going to happen. And then what exactly happened come 1st of January?
Right, yes. So what I think has happened for many lawyers is that they were getting many warnings about the importance of starting proceedings before the 31st of December at 11 p.m. And so the reason for that deadline was that the main EU instruments, Brussels 2A and the maintenance regulation, applied up until that point. And so they were transitional provisions as part of the withdrawal agreement that provided for the continuation of those instruments up until that point, for proceedings initiated up until then, but no longer. So that was the big rush. So where we were before December, we were in a land where jurisdiction for divorce depended on the jurisdictional requirements of Brussels 2A, and jurisdiction for maintenance depending on the jurisdictional requirements of the maintenance regulation. Both instruments also included, if you like, fast-track procedures for recognition and enforcement of orders within the EU. And so that was the world in which we lived before the 1st of January.
Yeah, and it worked quite well. It was really good. And then all of a sudden, 1st of January happened. It was like, ooh, when my clients called me and said, what do I do? It was like, not quite sure.
Yeah.
What exactly happens now when you want to start a divorce?
Not quite sure. Yes, not quite sure, but obviously relax everyone, because the reality is that it's not a complete disaster. I think that's the main thing to be saying to solicitors, to clients, to everyone. It's not a complete disaster if you haven't been able to issue your proceedings before the 31st of December. It's not a big deal in many ways. What it means in terms of recognition and enforcement is that instead of having a fast-track procedure on the EU instruments, you will be looking for recognition and enforcement on the different international instruments or on the rules of domestic law. So what this really means is that, one, we need to familiarize ourselves with international instruments that allow for recognition and enforcement, the instruments that replace Brussels 2A and the maintenance regulation. such as the 1970 Hague Convention on Divorce. And other than that, the main thing that we need to do is to have lots of colleagues all around Europe that we can just call when something arises, to ask them, well, is your country a party to X convention, yes or no? What are the domestic rules on recognition enforcement to the extent that they're relevant? I think it's important to note that thankfully all EU countries are parties to the 2007 Hague Maintenance Convention, which comes in to replace effectively the maintenance regulation as far as recognition and enforcement of maintenance orders are concerned. So that in the realm of maintenance, in some ways, it's really not the end of the world. It's a bit more problematic in the realm of recognition for divorces, because not all EU members are party to the 1970 Hague Convention on Divorce, which now applies reciprocally between the UK and some other countries, but not all EU countries. So in my view, it's very much when questions of recognition of divorces arise that we will need to pick up the phone and ask our lovely colleagues all around Europe what on earth we need to be doing.
So if we've basically got a divorce here and we wanted to have it recognised in a European country, we need to figure out what convention, if they're part of the convention, and if not, what they're party to,
exactly,
to figure out how we would do this.
Correct, yes. So a good example is France. France is not a party to the 1970 Hague Convention on recognition of divorces and legal separations. So in order to determine whether an English divorce is going to be recognised in France and under what condition, one needs to look at French domestic rules, because there is no other international agreement between the UK and France to date that provides for recognition, reciprocal recognition of divorces between the two countries.
Wow, okay. So really, you need to have everybody on speed dial to have that conversation as quickly as possible. But what does it mean? What does it mean for issuing proceedings? So, like, I have a case that was issued just before Christmas where it was here and in an EU country. And obviously, we know that the first one in time is the one that's going to stand and the other is going to fall away, although that's not really what's happening. But, that's what we were supposed to be doing. Now, can we do it in both countries? And how do we, if that does happen, how do we make sure that we come out on top? As in, if we wanted to make sure that our application in England came first.
Yes, so that's a very good question, and I think that's one of the main practical changes in the world of the post in the world after the Brexit transition. What used to be the rule, of course, is the lis pendens rule, i.e., the person first in time wins, and the court second seized would have a duty to stay its proceedings while the court first seized determines whether or not it has jurisdiction. In other words, if you're first in time, you can be reasonably confident that you've won the forum race. And that used to apply both in relation to divorce and in relation to maintenance. So divorce under Brussels 2A and maintenance under the maintenance regulation. Now, the other advantage of the European framework, if you like, is that we knew not only that this was the rule that we were going to apply in England, but we also knew that this was the rule that other European countries were going to apply too. So we were able to predict with a reasonable degree of certainty what other countries were going to do. That is no longer the case. So in terms of issuing here, my view is that being first in time is still extremely important, because inevitably what happens in forum races is that if you come to court after proceedings have been issued in a different jurisdiction, 9 times out of 10, in my experience, the judge is going to say to you, well, hang on a second, Ms. Reiser, other proceedings have been issued in France between the same parties in relation to the same cause of action. I'm not going to touch this until I know what the other court is going to do. So come back and see me once you know what has happened in the other jurisdiction. In terms of securing jurisdiction for divorce in England, one now must look at Section 5.2 of the DMPA in 1973, which very much incorporates the basis of jurisdictions contained in Brussels 2A as far as divorce is concerned. It also adds an additional ground of jurisdiction based on the sole domicile of one of the parties. Previously, this was only a residual ground of jurisdiction. This is now a primary ground of jurisdiction, although it is one that should be relied upon with caution because there can be issues in terms of recognition in other countries. So that's one thing to be aware of. Now, in terms of dealing with parallel proceedings, the test that the court in England is going to apply is the test of forum non-convenience, and that is contained in paragraph 9 of Schedule 1 of the DMPA in 1973. And so instead of asking, well, who is first in time, an English judge is going to ask which forum is the fairest and most convenient forum for the divorce proceedings to be taking place. Now, in order to know what say another court, the parallel court, if you can call it that way, or the competing court is going to do, then you would need once again to call your French colleagues or other colleagues to determine what test they are going to be applying in relation to parallel proceedings between them and the UK, which is no longer a party to Brussels 2A and the Maintenance Convention, the Maintenance Regulation.
Okay. So basically a whole lot of headache, and you definitely need to be speaking to your European counterparts.
Yeah, I mean, a whole lot of headache. I mean, in practice, do try to be first in time because it always helps. If you're not first in time in England, it's not the end of the world, but it's certainly not going to help your case, particularly if there has been a delay. So that's probably the takeaway in terms of forum races.
In your experience, and obviously, I can understand if you want to be very guarded in how you answer this, but in your experience, how are the courts throughout the country viewing that sort of thing? Do you have some courts where they're like, no, we're going to carry on saying that at first in time, we need to be looking at this? Or are there other courts that are like, really don't care if there's another jurisdiction in play, we're England, we're going to do what we want sort of thing?
Yes, well, I don't know whether...
Which is what I'm experiencing in Europe, by the way. I have cases in Europe at the moment where the European courts are like, don't care if you're England, you left. Literally, the judge is like, you've left.
You're out, yes. Well, I mean, it very much depends. I don't know whether it's very much a court-by-court issue or whether it's a judge issue, if you see what I mean. In my experience, the weaker the ties to the particular forum, the less sympathetic the judge is going to be. I.e., if the only connection that you might be having with the UK, with England, is your nationality or is based on your domicile, whereas you've always lived in France, your family is in France, their house is in France, all the assets are in France. I think it's the sort of cases where judges may not be persuaded. To carry on with the proceedings. So yes, I mean, ultimately that's an interesting point about all of these rules of jurisdictions. What they try and ensure is that while parties should have a certain margin of freedoms to determine where they want to be taking part of the proceedings, they should only be the proceedings should only take place where there is a significant connection with both of the parties or one of the parties.
Okay. That makes sense. So that's for the divorce. What about for proceedings? Because we touched upon maintenance. What about proceedings for maintenance, whether it's for children or spouses as part of financial remedies? What do we need to be careful of? What do we need to be aware of? Or do we need to be aware of anything?
One always needs to be aware. of law.
What, we just don't go in blind, kind of like fumbling about?
No, so the important thing to note in relation to jurisdiction for maintenance is that the rules have changed based on various types of maintenance. So maintenance flowing from the divorce under the Matrimonial Causes Act 1973 flows from jurisdiction for divorce. So the court has jurisdiction for divorce, the court has jurisdiction over maintenance flowing from the divorce. Now, if you are making an application under Schedule 1, different grounds of jurisdiction are going to apply. If you're making an application for a violation of a maintenance agreement under Section 35 of the Matrimonial Causes Act, there's another test. If it's an application under Section 27, failure to maintain, there is another test. Part 3, there is another test. And variation under Section 31 of the Matrimonial Causes Act, it's unclear. We don't really know, although there is a limitation on jurisdiction contained in Article 18 of the Hague Convention. Anyway, so you need to be very careful about the type of maintenance that you're asking for. And you need to check whether the jurisdictional requirements for that particular type of maintenance are met in each case.
Nice.
Everything you wanted to hear.
That's exactly what I wanted to think about. Okay, so now we just make jurisdictional maintenance that much more interesting.
Yes.
We talked briefly about, you mentioned briefly enforcement and recognition. What do we need to know about for the maintenance? Because when I talked about this with you before, I talked about maintenance, but we also mentioned whether there was other things such as capital lump sums and things like that. What do we need to look about? What do we need to consider? How do we go about that?
Yes. So the first thing to note is that the maintenance regulation was only ever concerned with maintenance. And in the same way, the 2007 Hague Convention is only concerned with maintenance. So maintenance in both of these contexts means a provision which is tailored to a party's needs, the aim of which is to meet a party's needs. Now, that leaves out what many European countries describe as matrimonial property, right? So we don't have this strict division in English law. An award can be needs-based or it can be based on sharing, but we don't really have those legal concepts. European countries do, and in fact, in many European countries, the EU regulation on matrimonial regimes is going to apply. So what this means for our purposes is first that we need to ascertain whether the part of the English order that we might be trying to get recognised and enforced in another country relates to maintenance or whether it might be seen as relating to something else. And so in this context, it's always helpful during the proceedings to have it recorded either on the face of the order or as part of the judgment when going all the way to a final hearing, which parts of the order are to be considered maintenance for the purposes of enforcement in European countries. Now, there's not a guarantee that the receiving court, if you like, is going to rubber stamp that assessment, but it is a start. Now, if the parts of the order which are going to be sought to be recognised or enforced do not fall within the definition of maintenance, if they relate to a sharing claim or matrimonial property, then one needs to, again, call the French colleague, call the Spanish colleague, or what have you, and ask, right, okay, well, is an order that relates to matrimonial property rights in the EU sense or sharing in the English sense, is that going to be recognised and enforceable in your country, yes or no? And if so, what are the things that I need to be aware of? The other thing to remember is that also that people need to think at the very beginning of the proceedings, where are the assets? If everything goes wrong, which jurisdiction would I rather be in if I need to get an order for sale of the house so that I can pay for maintenance arrears, etc., etc. So, and that goes back to what we were talking about earlier with the jurisdictional ground of sole domicile and the problem with weak ties to the jurisdiction is that you may well think, well, oh, I'm going to be so much better off if I'm in England and I'm going to rely on this ground of sole domicile or something else. But actually, if all of the assets are somewhere else, and if you are going to have to initiate proceedings there and you might have issues in getting your order recognized and enforced, then you might simply be better off initiating proceedings in the country in which you are going to try to enforce. So that's something that needs to be thought about from the outset.
Yeah, that's something that you should always be considering. That's very true. Difficult conversations to have with clients, though, when you're started saying to them, well, maybe you'd get a better settlement here, but really the main assets are in another jurisdiction and you should probably be doing it out there.
Well, and I think it's particularly difficult because many people will have this idea that, oh, England is such a great jurisdiction for divorce. I'm going to get so much more if I'm in England than if I'm somewhere else. And, that may well be the case, particularly if the parties have a separation of goods agreement, séparation bien. But again, it's about weighting the pros and cons and see where you're going to be ultimately better off if things go really wrong.
I have a really basic question that I mentioned, I asked you at another seminar you were hosting, which is, let's say I have the English divorce, so the document saying your marriage is dissolved, and then the order in regards to a financial settlement saying, yep, this is how you separate your finances, but I need to have this registered in another jurisdiction. For example, in France, you need to go to État civil and tell them I'm now divorced and I need to have my livret de famille updated saying that I'm divorced, but I need to have the document approved in that jurisdiction. Before, we would just make an application, Article 39, it gets stamped by the judge that granted your divorce, and then you could just translate that and send it off to Europe, and that's fine. I'm assuming that now there's no hard and fast rule, there's no rule for this. You can do whatever you want effectively, or whatever that country wants you to do to have the document registered over there.
Correct. So the first point of call is going to be the foreign état civil or equivalent to see what steps need to be taken in their jurisdiction for the divorce to be recognised. So perhaps it might not be necessary to take any particular administrative steps if all that a person wants is to be living in that country and remarry without necessarily wanting to initiate proceedings there. There's an important difference between recognition and enforcement. Of course, a judgment for divorce can be recognised, but there's nothing to be enforced. But if that judgment, typically in European countries, includes financial provisions, then it is not just a divorce in the English sense, it is a divorce and a financial order, and that order may well have to be enforced. And then in many countries, in order for something to be enforced, then there is a required administrative procedure that needs to be gone through. So the first point of call is going to be the authorities of the country in which you are seeking to get the divorce recognised.
Okay, just add an extra layer of complication now. I'm assuming that if you're doing an enforcement application, you're going to need to go the old-fashioned route of, which is what you do everywhere else, is to apply to have that order transferred over into that jurisdiction. Does that mean going through service through the High Court system here? So transferring it from our court to their court through the court system, or do you just rock up to the court and say, "Can I please have this registered?" What would your advice be?
Yes, no. So again, if we're talking about maintenance orders, the mechanism for recognition and enforcement of orders is done primarily via the mechanisms included in the 2007 Hague Maintenance Convention. And so the primary mechanism containing that convention is via the central authorities. And that is a very common enforcement mechanism, in particular for child support. Now, in almost every case, well, actually, no, scrap that. In every case, the order is going to have to be registered in the first instance before it can be enforced. And that is a very common mechanism, and that's not a surprising mechanism for enforcement of foreign orders. So yes, so registration is a necessary step under the 2007 Hague Maintenance Convention. Now, again, if you're talking about an order that's not relating to maintenance, that's relating to something else, then you can't go through the Hague Maintenance Convention. You've got to go through something else. And so, but whatever the instrument you are going through, as it were, registration, by and large, is a very common, if not the most common, preliminary administrative steps to enforcement in a foreign jurisdiction.
Okay. I think the last point on my list was just one word with a question mark. Children.
Yes, children. Well, I mean, the good news in relation to children is that not much is changing in terms of jurisdiction at the very least. So the primary ground of jurisdiction is going to be the habitual residence of the child. And that, again, that makes sense intuitively, right? We want the courts, which are the closest to the child, to have jurisdiction over matters relating to the child. So practitioners should be looking at the 1996 Hague Convention on jurisdiction, applicable law, recognition, enforcement, and cooperation in respect of parental responsibility and measures for the protection of children. They should also be looking at the 1980 Hague Convention on child abduction, which many practitioners will already be familiar with. But so in that respect, not many practical difficulties, I would have thought.
Okay, so at least that's one thing that we can be a bit more relaxed about.
Yes, although again, perhaps the next person you might want to have on your podcast is someone who does a bit more of that work than I do, and I'm sure they will tell you, no, actually, this is all terrible. But at least on paper, and I say this very candidly, at least on paper, it doesn't look too bad. I mean, the other thing to remember is that there was a time when the UK was not a party to Brussels 2A and to the maintenance regulation, etc., and everyone survived. So there was a world before the European Union, and there are statutory instruments for reciprocal recognition of maintenance orders and judgments and what have you, which were in place before and which continue to apply to date. The big inconvenience for all of us is that we have to learn them, but they do exist. They do exist, and then. The main difference in our practices, I think, is that we are going to have to be a lot more in touch with our European colleagues, and think about such issues at the very beginning, because we can't predict in the same way that we could what a French court or an Italian court is going to be doing. So that's going to be the primary difference in relation to your practices. And then, of course, there are lots of questions that remain to be answered, for instance, as to how Section 5.2 of the DMPA is going to be interpreted by English courts now that it is no longer bound by the jurisprudence of the European Courts of Justice. We'll have, I'm sure, arguments about whether you can get interim maintenance here, say, if the main proceedings are taking place in another jurisdiction. That used to be covered by the case of Vermouth and Vermouth, which was obviously an EU case, as it were, a Brussels 2A / maintenance regulation case. Now, is an English court going to follow that line of thinking or not? we'll just have to see, and we just have to hope that none of our clients are going to be the test case that determines these issues. But yes, and then another point to make is that there is still a potential chance, perhaps a slim chance, but who knows, that the UK is going to accede to the Lugano Convention, which might bring us back to a regime for recognition and enforcement of maintenance order, which is closer to what we were used to under the maintenance regulation. The UK has expressed its intention to accede to the convention, but that has not yet been approved by the European Union. So we'll have to watch the space.
So for the moment, we're as we are, but there could be some clarification later on.
Yeah, possibly. I mean, some people would say, well, no, actually, the Lugano Convention is not going to bring much clarification because it is an outdated instrument that was based on Brussels I, that wasn't updated in the way that the maintenance regulation was, etc., etc. So, I mean,
Roxane, I love how you kind of build me up and you're like, yes, this may happen. Then you're like, yeah, but no. Yeah, but no, not really.
Yeah, but no, I mean, you know, it is in my view, it would be better, certainly for practitioners, to be under the Lugano Convention regime, but the Lugano Convention also has its own complexities. So you know, you win some, you lose some.
So I've picked up 10 points from what we've talked about today, 10 kind of like highlights, like things to remember. I'm going to say them and you're going to tell me whether I've got it right and whether we can stick to them as being helpful. The first one is don't panic.
Yes.
The second one is have a network in the EU and contact them all the time.
Pretty much, yes.
So that might be something to consider, Roxane. Do we need to set up an EU network that we can be referring to?
I mean, they all hate us, so, you know, we might as well.
Yeah,
you know.
Very true. Then I have check that the country you're dealing with is part of a reciprocal convention or not. And if they aren't, what the local law would do. In regards to divorce, still best to be first in time, but ultimately it's going to be a question of which is the best or fairest jurisdiction, depending on where the assets are, etc.
Yes.
Maintenance, which type of maintenance you're looking for, and then what are the jurisdictions or what are the different rules in regards to the type of maintenance you're trying to get?
Correct. Yes, jurisdictional rules.
When you're making a financial order, make sure the order sets out which part of the order is considered to be maintenance, so that it can be so that it's going to be hopefully easier to enforce abroad. And for the rest of the order, call a colleague abroad and find out what they would do.
Yes.
Consider at the start of the matter where the assets are and where you'd rather be if you were trying to enforce an order in regards to those assets. So basically have that difficult conversation with the client that maybe it's better to be doing it in one country rather than another, even if it's not the best one for them. Register the divorce abroad, speak to your local colleague. I've got a lot of these points, speak to your local colleague throughout. To enforce any order, the first step is registration. So focus on registration. And then the last one is maybe Lugano.
Question mark. Correct.
Question mark. So, I mean, you know, I think you've made me, considering I do this day in, day out, I think you've kind of cheered me up immensely. It's made me feel like, oh yeah, actually I do know what I'm doing. And this seems to be, you know, not as catastrophic as I'd been worried about for the past 15 months.
Yeah. No, and just remember, if you don't have the answer, you know, someone else probably does, and so you just need to have their number. Maybe that's the takeaway. Just get those numbers quickly.
I love that. Yeah, I'm going to start just randomly calling various lawyers in different countries. Do you speak French, English? Can I speak to you in one of those languages?
They're going to love
a meeting.
They're going to love it. Do it.
Is there anything you want to add that I've said wrong or that we haven't touched on?
No, nothing in particular. Only good luck to you. Good luck to everyone, frankly.
Thank you. Thanks so much, Roxane, for doing this so last minute for me. Thank you very much.
Thank you. Pleasure.